You will get a copy of the judgment in both versions as soon as I have delivered this judgment. These are the reasons. Section 113, first subject of the Criminal Code, as it is now before this court, provides in general terms for the possibility of imposing a life sentence. The history of this code goes back to the Criminal Code Bill, which was introduced in the Parliament of the Netherlands Antilles on the 22nd of December 2009. After the constitutional transition that took place in 2010 and pursuant to additional Article 4 of the Constitution, the bill for the new Criminal Code was debated before the Parliament of St. Maarten, at which time it contained a Section 28, which provided that a life sentence prisoner, after having served at least 20 years of the sentence, shall be released conditionally by the Court of Appeal if in the court's view continued imprisonment would no longer serve a reasonable purpose. If the court did not grant a conditional release, a further review should take place periodically every 5 years. By the fifth memorandum of amendment to the bill, Section 28 was withdrawn from the draft Criminal Code. The Ombudsman submitted that the removal of Section 28 from the original bill constitutes an infringement of Section 3 of the Constitution, which prohibits cruel, inhuman, or degrading treatment or punishment. In her view, the removal of this provision, resulting in a situation whereby life sentence prisoners have no other possibility of being released than by way of a pardon, also constitutes a violation, in her view, of Section 30, subsection 1 of the Constitution, requiring that, quote, all persons deprived of their liberty shall be treated with humanity and with respect for the dignity inherent to human beings, unquote. The government, in answering this particular point, averred that the court had no jurisdiction to adjudicate this issue, and in any event, the Ombudsman had no standing to raise it, since Section 127 of the Constitution only allows the Constitutional Court to judicially review the constitutionality of ordinances and some other legal instruments, but not of the removal of a provision from an earlier draft of the legislation that is before the court. The Constitutional Court is of the view that the submissions of the Ombudsman with regard to this matter can and should reasonably be read as advancing the argument that the Criminal Code re-establishes the possibility, already existing under the current code, of imposing a life sentence without allowing the life sentenced prisoner an opportunity at some point of time after the imposition of the sentence to have a court review the appropriateness of the continuation of the sentence. The argument is therefore not so much that the removal of the section constitutes a violation of the Constitution, but rather that the lack of a possibility for review as created by the removed section may result in such a violation. During oral argument, counsel for the government conceded that a legal rule currently existing under a legal instrument and re-established under new legislation replacing the former can indeed be reviewed by the Constitutional Court with respect to its conformity with the Constitution. The Court agrees with this view and it adds that no constitutional savings clause exists on the basis of which existing legislation reappearing in new legislation would be saved from judicial scrutiny by this court. For these reasons, the court finds that it has jurisdiction to entertain this matter and that the Ombudsman has standing to raise it. At the hearing of the case, the Ombudsman sought to add another complaint, arguing that the government had wrongly omitted to consult the Council of Advice before introducing the fifth memorandum of amendment. Be that as it may, this complaint is out of time and will therefore not be entertained by the court. Of course, similar but timely filed complaints brought by the Ombudsman with respect to other parts of the new criminal code will be dealt with by this court in its final judgment. With regard to the issue which the Ombudsman placed before this court, that is, whether in light of Section 3 of the Constitution, periodical judicial review of a life sentence would be required at some point in time after the imposition of that sentence, the court notes that on the 9th of July 2013, 1 week after the public hearing before this court in Sint Maarten, the Grand Chamber of the European Court of Human Rights, in the case of Winter and others against the United Kingdom, delivered a judgment dealing with an issue quite similar to the one currently before this court. The European Court considered that the imposition of a life sentence on an adult offender, quote, is not in itself prohibited by or incompatible with Article 3 of the European Convention on Human Rights or any other article of that convention, unquote. But that, a quote again, the imposition of an irreducible life sentence on an adult may raise an issue under Article 3. The court stated that, quote, no issue arises under Article 3 if a life sentence is de jure or de facto reducible. It also found that, quote, for a life sentence to remain compatible with Article 3, there must be both a prospect of release and a possibility of review, unquote. The European Court further considered that in the context of a life sentence, Article 3 must be interpreted as requiring reducibility of the sentence in the sense of a review, which allows the domestic authorities to consider whether any charges of in the life prisoner are so significant and such progress towards rehabilitation has been made in the course of the sentence as to mean that continued detention can no longer be justified on legitimate penological grounds, unquote. Although the court stated that it is not its task to prescribe the form, executive or judicial, which that review should take, nor to determine when that review should take place, it observed, quote, clear support for the institution of a dedicated mechanism guaranteeing a review no later than 25 years after the imposition of a life sentence, with further periodic reviews thereafter. The European Court concluded that where domestic law does not provide for the possibility of such a review, a whole life sentence will not measure up to the standards of Article 3 of the Convention. Moreover, the judgment clarifies that the review of a life sentence should be broader than one solely based on so-called compassionate grounds. Given the well-nigh similarity of Section 3 of the Constitution and Article 3 of the European Convention, this judgment of the European Court would appear to be relevant for an assessment of the compatibility of Section 113 of the new criminal code with in particular Section 3 and possibly Section 30, first subsection of the Constitution. In the circumstances, the Constitutional Court considers it necessary to allow the parties to address the possible implications of this judgment for the above-mentioned assessment on which this court must embark. To this end, the Constitutional Court will request both parties simultaneously to file written submissions, after which they will have an opportunity each to file again simultaneously a written reply. In particular, the parties are requested to give their views on whether, and if so, to what extent the judgment of the European Court should have a bearing on the interpretation of Section 3 of the Constitution, and whether, and if so, to what extent this judgment, also in light of the answers to be given to the questions formulated in the next paragraph, has any consequences for the compatibility of the present provision in the new criminal code with Section 3 of the Constitution. In connection with the above, the Constitutional Court wishes to request the government to answer the following questions in their written submissions, to which the Ombudsman may react in a written reply. A. What is the number of life sentence prisoners in Sint Maarten? B. What is at present the time served by these respective prisoners? C. Does the government know of any petitions made by or on behalf of these prisoners requesting a pardon? And if so, at what point in time after imposition of the sentence were these requests made? What was the result of these petitions? D. If any of these matters have been disposed of, has there been in any of them a departure from the advisory opinion of the sentencing judge? E. Section 118 of the Constitution reads as follows. A pardon shall be granted by national decree after an advisory opinion has been obtained from the sentencing judge, in compliance with regulations established by or under a national ordinance. As far as the Constitutional Court is aware, no such national ordinance as referred to in this section has as yet been established. Is this impression accurate? Are efforts being made to establish the ordinance, and if so, what is the status of this piece of legislation? F. In the explanatory note to the aforementioned fifth Memorandum of Amendment, by which the periodic judicial review of life sentences was removed from the draft legislation, the government explicitly referred to the possibility of requesting a pardon in order to have even a life sentence reduced, in the course of which procedure the personal circumstances of the prisoner are to be taken into account. In this context, the government specifically referred to the judgment of the Hoge Raad of the 16th of June 2009. Is the government in a position to affirm that with this reference it is intended to express the view that a pardon will be granted if, in the terminology of Section 2b of the Dutch Gratiewet, on a balance of probabilities, it can be assumed that with the continuation of the prisoner's detention, no reasonable penological purposes will be served. Or, in the words of the European Court in Winter, paragraph 119, continued detention can no longer be justified on legitimate penological grounds. Any further decision is adjourned until the date given hereunder. Decision is that the Constitutional Court first requests both the Ombudsman and the government simultaneously to file written submissions as mentioned in paragraph 2.8, not later than the 6th of September 2013. 6th of September. Second, request both the Ombudsman and the government simultaneously to file a written reply not later than the 27th of September 2013. Adjourns any other decision until Friday, the 18th of October 2013 at 10 a.m. This interim judgment has been rendered by Justices Wit, de Boer and Vermeulen, respectively President, Member and Substitute Member of the Constitutional Court of Sint Maarten, and delivered on behalf of the Court by its President in open court and in the presence of the Registrar, Richard James Christina, through video conferencing on this day at 1:30. This is the interim decision of the court. It will result in some delay in getting the final judgment out, but as you have seen, the court would find it necessary that this is a very important, because this is a very important development in European law, which has some bearing on Sint Maarten law. As you know, the decision of the European Court before our hearing was that probably some regulation which contains gratie, a pardon, would be sufficient, but it would seem that under the new decision, that picture has somewhat changed, and therefore it is necessary, and I think it would even be improper for us to give a decision if we would not allow the parties to give their views on the consequences, if any, of this new development. So this is the decision of the court. As I said, it will be available right away, both in Dutch and in English. I want to observe that this is, in a small way, still a historical event, as it is the first judgment of this court. It's also historical in the sense that I think since the 19th century, this must be the first judgment which is delivered in English in Sint Maarten. As you may not know, but in 1869, when for the first time there was a court in Sint Maarten, the intention was that all the judgment would be given in Dutch. But at that time, none of the layman judges in Sint Maarten were able to understand or speak Dutch. And out of necessity, they said, well, nobody will blame us that we give a judgment in English. And 3 years later, the legislature condoned that fact, and it was then possible since the 19th century to deliver judgments in English. But of course, that is a period which is far away behind us. But anyway, this is a new chapter in a new country, and as it is mainly English-speaking, the court thought it appropriate to deliver the judgment in English and to have both a Dutch and English copy of it available. So this is what the interim decision of the court contains. You will have till the 6th of September to file the written submissions, and the government is asked to answer the questions as I just mentioned. And then there will be a reply on the 27th where you can react on each other's submissions. And then 3 weeks later, the final judgment will be out on all the other, and also including this one. This is the decision of the court. Thank you.
Thank you. Thank you.